Chuck Michel, California civil rights attorney with Michel and Associates, with us on the program this afternoon. Chuck, how are you, sir?
Good morning. I'm good, Cam.
I hope you had a great annual meeting. I saw you literally as I was walking into the hotel on Thursday night. It was about 11 o'clock, and you were standing outside, and you were deep in conversations with somebody, and I didn't want to say hi and interrupt you because I figured I'd see you at some point throughout the weekend, and then I didn't.
Ronnie Barrett and I were talking business.
Yes, you were. So I hope that you had a good annual meeting there in Nashville.
It was a great experience. Nashville is a fun city. Not to take away from Louisville, where we're going next year,
right.
But Nashville does have some things that some of the other cities haven't.
Absolutely, and it was just a great weekend. It was a great time. I loved I loved walking out of the Music City Center in the afternoon, Chuck, and there were thousands of NRA members who were outside on the street. It was like this street festival atmosphere. It was a lot of fun.
That was a great part of it. I had never seen that street festival aspect really before. I went, and we've tried it, but it never really caught on like it did there. That was a great show. It was inside and outside.
Absolutely, and I'm sure you had a lot of folks asking about the Peruda case and what's gone on since the Ninth Circuit said, okay, yes, we are going to hear this en banc. You've had the Sheriff of Orange County, Sandra Hutchins, now reverse course and say, no, self-defense isn't a valid reason for us to accept your application. And I understand now the San Diego Sheriff has also reversed course, and they're sort of back to the original arguments that they were making before the three-judge panel or all along here in the Peruda case.
Well, that may or may not be the case. We're trying to get to the bottom of that. There was a San Diego Union Tribune article that sort of implied that. But Sheriff Gore, through his county counsel's office, months ago said, I don't want to pursue this case any further. And the Attorney General is, ready, willing, and able to step in for them through one procedural mechanism or another. So we're sort of turning up the heat on Sheriff Gore the same way we've been turning it up on Orange County Sheriff Hutchins to not defend the case and not try and adopt or defend some kind of a restrictive issuance policy. Now, these are conservative sheriffs, or at least they claim to be, and if you're a conservative-thinking sheriff, the three-judge Peruda panel opinion was a conservative-thinking judge writing a beautiful analysis of what the Constitution requires, and no matter what the Ninth Circuit ultimately says, they should go along with that reasoning because they have the discretion to adopt Peruda even if they're not required to. So we're legally. So we're putting the pressure on Sheriff Gore to let the Attorney General do the work. Otherwise, he's going to be the one tarred with the brush as the guy who's fighting against the Peruda rationale for liberal issuance of licenses to carry.
Absolutely, and as you say, Chuck, these sheriffs, they do not have to go back to a standard that does not recognize self-defense. The arguments that we saw in this opinion, the decision that was handed down, while the case may be revisited, those arguments are still, I think, legitimate and valid arguments. I mean, we go back to this idea of what was said in the Heller case, that the core purpose of the Second Amendment is self-defense, and the fact that in this case right now in San Diego County, self-defense is not seen as a valid reason for you to obtain a concealed carry license. Therefore, there is no way for you to bear arms for the purposes of self-defense in San Diego County unless you are a specific a class there within the county. How on earth can that survive constitutional scrutiny?
Well, unfortunately, we've got some judges who see the Constitution very differently, but it shouldn't. And in law, we define case authority as either mandatory or persuasive. So even if it's not legally mandatory that a court or a sheriff follow a particular a decision, they can be persuaded by it. And again, if you're a conservative-thinking sheriff, this is a conservative-thinking judge that wrote this Peruda three-judge panel opinion ruling, they should be persuaded by it, they should welcome it, they should embrace it, and they should follow that ruling and accept self-defense as the good cause that is all you need to get one of these licenses, and join the other 42 states who are already ahead of the game on this way of thinking.
So, Chuck, what is the timeline here that we're looking at for the en banc review?
Sometime during the week of June 15th, they will have the oral argument in San Francisco in front of the 11 judges. Between now and then, another round of amicus briefs will be submitted. They all got to go in about 3 weeks before that June 15th week for the oral argument. So right now there is a big effort to get those amicus briefs together and submitted going on, and it looks like we're going to have some fairly high-profile folks weighing in on our side in the Peruda case, and I'll keep that. I'll give you a scoop on that as soon as we confirm those. But for now, we'll just keep it vague. There's some very important people who want to see the Peruda opinion upheld and believe in the right to keep and bear arms especially, and agree with us on this. So they're going to help us out.
That is fantastic. All right. Well, listen, when you can give us more details, please do. And in the meantime, thank you for joining us today, sir.
My pleasure, Cam. Thanks for having me.
All right. We'll talk to you soon. Chuck Michel, California civil rights attorney.